Welcome to Utah Bankruptcy Questions and Answers. This is a video series where we answer questions about filing bankruptcy in Layton, Utah. I'm attorney Amy Butters, and I hope you find this information very helpful and informative.
Welcome to video number 8. Today we're going to talk about what happens to your home and your car when you file bankruptcy. This is probably one of the most common questions, and don't worry. Okay, don't panic. There are very few instances where you go into this and you end up with worst case scenario, especially if you have a good lawyer. Okay, so don't hit that panic button just yet. Here's some myth versus reality when it comes to having cars taken or houses taken or whatnot. First of all, having non-exempt property, which you remember we talked about that in the earlier videos, is rare. Okay, you got to understand that the bankruptcy code was designed around having you in mind. Okay, so they know that you aren't going to go do this if it means you're going to go live in a van down by the river. Okay, they know that that's not what people are looking for. We want relief, and if we lose everything and have to kick our can down the road, that's not relief. That's not what we're looking for. Now, if you're in a Chapter 7, okay, you can make arrangements to pay a creditor what they might have reasonably received from selling non-exempt property. So let's use a Utah example. In Utah, you get an exemption for your vehicles, and it's $2,500 in vehicle equity per spouse. All right, let's say you have 2 cars, and between the 2 of you, you have $10,000 worth of equity. So now, combined, you guys have 5 covered in your exemption, but there's 5 out there that's not covered. Well, you know what you could do? You could talk to the trustee of your case through, have your lawyer present an offer to the trustee that says, rather than losing these vehicles, which we need and we want, so that we can continue going to work and doing the things we need to do, rather than doing that, let's create a payment plan where we can pay that $5,000 to the estate. That's absolutely something that can be done so that you're not losing property like that, okay? So, like I said, don't panic. There's usually some way to figure out a solution to your situation. Now, in a Chapter 7, if your mortgage is current and you don't have more than $20,000 in equity per spouse, so $40,000 total, you can simply continue paying your mortgage, but the new bankruptcy rules that were passed in 2005 may require you to what's called reaffirm, which is a declaration that you make through the courts, declaring your intention and your agreement to continue paying and being liable for that debt legally. And that is not something that you should treat lightly. Something you absolutely need to talk to your lawyer about, because it may not be a good decision for you to remain liable for the debt. It used to be in the good old days before the 2005 Reform Act that you could file bankruptcy and now you're not legally obligated to pay your house, but you continue paying your house. And that way, if something goes wrong in the future, it's already been handled, but that's no longer really the case anymore because they do ask that you reaffirm on that debt. Chapter 7 temporarily stalls the foreclosure, and this is something that I want to talk about because my background is in real estate, mortgages, foreclosures, helping people with loan modifications and short sales and those kinds of things. And a common tactic that I would see when mail would come to these people is I would see postcards and letters and things, and what they would say all the time is, filing bankruptcy doesn't stop the foreclosure, or it only does so temporarily, but they're not giving you the whole story. Chapter 7 only stalls it temporarily, and if your goal is to keep the house, then yeah, you need to do something other than just file Chapter 7. But Chapter 13, on the other hand, if you make the payments, stops the foreclosure permanently and allows you to keep the house. So it's a little bit misleading. They're trying to use a scare tactic to say, don't file bankruptcy, sell your house to me, or whatever it is they're selling. And again, let's clarify too, the homestead exemption. This is an important thing. It's $20,000 per spouse, and vehicles are $2,500 per spouse. What that's going to do is it's going to take that chunk of equity, that $40,000, and it's not only going to protect it from, say, the trustee wanting to sell your house to pay the creditors back. He can't do that. But it also protects it against other creditors. You know, they can't just come in and lay claim to that because you've exempted it through your homestead exemption. Now, if you enjoyed this video, but you feel like you still have some unanswered questions, don't worry, we've got you covered. We've actually created an entire video series that answers all the commonly asked questions about bankruptcy in Utah. Go ahead on over to our website, LaytonBankruptcyLawyers.com, and there you'll be able to download our free ebook, and you'll be directed to our main website where the entire video series is located.